If the parties, interpreters, and court reporters are ready to proceed, then we may proceed.
Thank you, sir.
Okay. Continuamos, licenciado Martínez.
Mr. Martinez, shall we continue?
Yes. Could you have a look at the document at tab 56 in volume 2? This is exhibit R20. You refer to this report in your statement, don't you? Now, if you could just go over to page 2, right at the bottom there, conclusiones. And so there's the first conclusion in this report from CNAC. And you would agree that what the two CNAC inspectors who attended the site are reporting here is that they think there are possible wetlands. You agree with that?
Creo que tiene que prender el micrófono.
Please use your microphone. Correct. I agree with that statement, sir.
And this, you're aware from this 3-page report that the inspection was done over the course of half a day, yes? I mean, you know this document well, don't you? Because this is one of the most important documents in the case against Mr. Aven and Mr. Damjanich. Yes.
Lo he revisado, pero no lo manejo.
I would need to review it because I don't know it by memory. I would have to review it to ascertain that they were there only half a day.
Any soil studies for the purposes of this report, did they?
There's no indication that they did any soil studies, but they request information. They request that CNAC Department of Wetlands takes the pertinent action to determine the wetlands.
Formal identification or conclusion that there are wetlands on site, no delimitation of wetlands on site that's recorded by way of this document, is there?
Correct. They indicate that there are 2 potential wetlands and that the Department of Wetlands go forward in order to determine whether this is such.
Just in respect of the time taken for the site visit, we can see actually in the text above the conclusiones heading, you can see that the site visit finished at 1:30 p.m. So it would be a fair summary to say they were there for no more than half a day, right?
Desconozco.
I don't know when they arrived, but indeed it does say that they left the site at 1:30.
Now, this report, this 3-page report indicating the possibility of wetlands but seeking more information, was of course superseded, wasn't it, by the CNAC report that appears at Exhibit C72, actually tab 13 in your files. If you just go to page 6 of that document, it actually says page 3 at the top, but it's the 6th page in the document. If you go down to the last paragraph, you will see that there is the conclusion that there are no wetlands on the property. You see that? The conclusion is on that paragraph, bottom of the 6th page of that document, there is recorded the conclusion that there are no wetlands. You see that?
Correcto, eso dice en esa.
Correct? That is what this paragraph states.
On the 16th of July 2010, you see CNAC saying there are no wetlands, and if we just go back to the previous document, apologies for jumping around again, R20 at tab 56, you should still have it open, I think. This is the reminder, just to remind you, this is the preliminary, okay, the indication that there may be wetlands, it needs investigation. And could you just look at the last paragraph on the first page of the document? It's not completely clear, but I think you'll be able to make out the text. And just read it onto the record from Exhibit R20, that last paragraph on the first page of the document. You see it? So it refers to possible wetlands and so on. Just read that out.
No escuché lo último de la.
I'm sorry, I didn't hear the last thing that you said, please.
All I want you to do is just read onto the record this last paragraph on page 1 of R20. This is the CNAC report of 1 October 2008. And just read out the text there at the bottom.
Licenciado, no sé si la copia suya.
I don't know if your copy is more legible than mine, but this is illegible. I don't want to read words that don't exist. I don't know if the tribunal would like to see this, but I really can't read this based on the illegible text.
Both are looking at the paragraph that he should be reading, because there might be
I think
an
he is.
error.
I think he is looking at the right page. And as I indicated, it's not perfect. It's the respondent's exhibit. It's not perfect. I think in anyone's copy, this portion of the text. I put it to Mr. Martinez that although that maybe 6 words or 7 words in the paragraph are not clear, I would accept that. Actually, you can read through most of the text there, and it would not be particularly difficult for you to do so. So I invite you again to read the paragraph onto the record.
if you can please read it, and if there's any doubt about the text, well, then you can state that. Based on what I can read, there's a word and a number I can't see. Potential wetlands, which according to, and then I can't read the word. Then I can't read the other word. Then it says moose. I can't read it. Then it says conden. High. Then I can't read it. Water due to obstruction of culverts.
I've given you a couple of chances to read through text, which is a lot clearer than you might suggest, but we'll leave it there. The text is there. I think the members of the tribunal can read it later on. Now, if we could turn now to binder tab 17, this is Exhibit C283. This is Setena Resolution 2086-2010. And you see down at the bottom of the page, of the first page against Sexto, there's a reference to the complaint filed by Mr. Steve Buccellotto. And you can see, if you go to the very last page of the document against Primero, I think it's the penultimate page rather than the last, but anyway. Underneath, in the section headed Por tanto, la Comisión Plenera resuelve, and then you can see against Primero that the complaint is rejected. You see that?
Correcto, eso.
Correct. That is what it says under first.
And you must have reviewed this document as part of your investigation, right?
Correct. I did review this document during the criminal investigation that I conducted.
That the complaint that's being dealt with here wasn't the first time Mr. Buccellotto had filed a criminal complaint in relation to alleged wetlands on the Las Olas site. You knew that, didn't you?
Sí, correcto.
Yes. I knew about this complaint that had been presented to the Ombudsman's office that was then sent to Setena. I don't know the kind of processing that took place there because I don't work in these institutions. That's not under my ambit.
And presumably you would also have known of the fact that Mr. Aven had filed a defamation suit against Mr. Buccellotto in relation to similar issues. You knew about that at the time?
Sí, correcto, en la indagación.
Yes, during the inquiry, which is the first moment when the defendant is called upon by the prosecutor, there was a mention that Mr. David Aven had actually presented a complaint against Mr. Buccellotto for defamation.
So you knew perfectly well that there was a contentious relationship, a contentious situation between Mr. Aven and Mr. Buccellotto, between the developers of the site and Mr. Buccellotto. You knew about that, didn't you?
Mr. Aven mentioned this complaint that he had filed. I didn't know if it had been resolved, and so I didn't know if Mr. Buccelato's complaint about him had actually been taken on by the courts. I don't know what kind of proceedings Mr. Aven had actually filed against Mr. Buccelato.
Thinking back to your answers early on today, in which you confirmed that it would be a relevant consideration if there was some sort of vendetta underlying or motivating a complaint, you would accept, wouldn't you, that the context of a complaint is relevant to your assessment of what to do with that complaint, right?
Sí, efectivamente.
Indeed, it is a consideration that must be borne in mind. In this specific case, Mr. Buccelato's complaint was it was possible to confirm this through other evidence. If the only evidence that existed with regard to the author, perpetrator of these actions, if that was just Mr. Buccelato, that then this conflict between Mr. Aven and Buccelato would have been evaluated by me to see whether what he was saying was true or not. But in this specific case, independent evidence was obtained with regard to the events that were occurring and also related to Mr. Aven's involvement in those events. So the complaint presented by Mr. Buccelato, what it did was generate notification of a crime in the Office of the Public Prosecutors that we then investigated and that we were able to confirm with independent sources that were not Mr. Buccelato.
To tab 19 in the files, that should be in volume 1. This is exhibit C101. It's a CNAC report dated 3rd January 2011. You know this document, Mr. Martinez?
Correcto, lo conozco.
Correct, I do know it. This is the document that Mr. Picado presented. It was a report he sent.
To page 3 of the report. You see there at the very first conclusion there is that there is a statement that there are bodies of water on site that are apparently classified as wetlands. You see that?
Correcto.
Correct.
As a prosecutor or as a lawyer of any sort, you will understand that that is not going to be a conclusive position. You need to do much more in order to establish, as one of the various elements of the offences in question, that there was a wetland, right? Right?
Correcto.
Correct.
Just to recap, there are, in terms of what you've had from CNAC by this point, you've had 2 CNAC reports that confirm there are no wetlands on the site, and there are 2 CNAC reports which refer to a possibility of wetlands, or apparently there being wetlands on the site. There's nothing else from CNAC, is there, making a conclusive statement, there are wetlands on the site at this point? There's nothing else on the record, is there?
No, eso no es correcto.
That's not correct. There is a report from the National Wetland Programs that was requested by our office that does confirm the existence of wetlands on the site.
Looking at this report, you would accept that there's an obvious inconsistency, a clash between what CNAC is saying here and what it was saying in its report on 16 July 2010, to which we've already gone, which they rejected the idea of there being wetlands on the site. You understood that there was an obvious contradiction there, right?
Sí podremos.
Yes, if we look at these reports separately, we could consider that there is inconsistencies between them, but the work of the prosecutor means that you have to weigh all the information available and look at when the information was issued, interview the people who drew up the reports, and based on that analysis and that weighing that is done by the Office of the Public Prosecutor, when you draw conclusions about the investigation, a decision must be made to apply some principles that are used in criminal procedure, for example, of maybe probable cause. To draw up an accusation, there must be a degree of probability that a crime has been committed and a degree of probability with regard to who's the perpetrator of that crime. The Office of the Public Prosecutor lays out an accusatory thesis, and then in the intermediate stage, then there is an independent judge, independent from our office, that decides on that, and then there's a trial judge that makes a decision as to whether the evidence provided by the prosecutor, if the defendant should be punished based on the evidence presented. And so several aspects were weighed at that time, and we leaned to use the reports that indicated there is the probability that these wetlands existed. But then the report from the National Wetlands Program is conclusive, and that there were wetlands and that they had been drained.
Just before we leave this document, if you could just turn to page 4 of the document. This is in the recommendations section. You see at the top there against the number 2, you see the recommendation that you solicit an analysis of soils from the relevant agency, INTA. You see that?
Correcto.
Correct?
Soil quality being one of the mandatory features to establish before any conclusion on the existence of a wetland can be drawn, right?
Correcto, así es.
Correct, that is right.
You just go back to your statement, paragraph 20. You refer to the 1 October 2008 report.
Excuse me, counsel, which statement?
Yes, apologies, sir. The first statement.
Thank you.
So you see there that you make reference to the CNAC report of the 1st of October 2008. That's the report that we've looked at, which mentions the possibility of a wetland on the project site. So what you're saying in paragraph 20 of your statement, apologies, you see paragraph 20 of
Está
your
en
statement.
inglés esta versión que me... un momento, licenciado, es que me dieron la versión.
Please, one moment. I'm sorry. I'm looking at the English version, sir.
See how we get on. I'll do it in Spanish and you do it in English. So you have paragraph 20. You make reference, as I say, to
Correcto.
the CNAC report of 1 October 2008. You see that? So as you say in the last paragraph, this in itself was sufficient motive to continue the investigation in order to guarantee the application of legislation on environmental protection. Right? So what you're saying is that a 3-page report mentioning the possibility of wetlands was enough to proceed.
Sí, correcto, con este informe
Yes, with this report and other reports that also confirm the existence thereof, that when we made that conclusion, we considered that at this point we could go forward with the criminal investigation for that fact or for others as well.
But, apologies for overspeaking, you would obviously still need to do more in order to get to a point where you could be satisfied you would have a chance of achieving a conviction, right? One short report indicating a possibility is not going to be enough for that, is it?
sí, correcto, pero
Yes, that's correct. But as I said earlier, more information was obtained and that confirmed the existence of a wetland on the site. There was a report from the Wetland National Program that referred categorically and not as a possible. They indicated that there was a wetland on the site under consideration. Sin embargo,
There wasn't, though, any executive decree creating and delimiting any wetlands on the Las Olas site, was there? And in fact, there hasn't been to this date, has there?
it is correct. There is no executive decree declaring it to be a WPA for one of the operations as established in Article 32 of the law. No, there is no such decree.
And until September 2009, the law stated that there had to be an executive decree delimiting a wetland, right?
había
There was an indication in the wildlife protection law saying that they had to be created. However, for criminal purposes, there was a resolution of the constitutional room that said that the word creation was in constitution, that being a word that was used in the wildlife law, and the protection of wetlands, they said, had to be by their mere existence.
So you agree with me, and that happened in September 2009. So up until that point, you did need to have an executive decree, correct?
no recuerdo
I don't recall the dates on which that regulation was amended. I cannot recall it out, not by memory.
Just moving on to a slightly different topic, I wanted to check whether you were aware of the work of the local auditor in the municipality of Parita. This is Mr. Jorge Antonio Briceño Vega. Does that name sound familiar?
No, señor.
No, sir. I do know of no one by that name, nor have I seen any documents related to anyone bearing that name.
So you don't remember seeing any documents relating to analyses of municipality action undertaken by Mr. Briceño as part of your investigation? You don't remember seeing any of that?
None at all. Nothing. I don't recall having seen any information relating to analysis by a municipal auditor relating to the project. It's not my ambit to look at agreements or informations provided by municipal officials.
But if you as an investigating prosecutor discovered that the complainant had taken the same complaints through a different route through the municipality, and subsequently the municipality had taken steps, but subsequent to that the auditor had found that the municipality's actions were illegal, would you consider that to be relevant for dealing with the criminal issues that have been put on your desk?
We'd be basing this on an assumption that I would have known about that document, and actually we never saw that document in the criminal file. It wasn't provided by the defense throughout the investigation. So I would be speculating to a certain extent, even as to its content, because I never saw it.
That's absolutely right. I'm asking you to deal with the hypothetical that you had. I accept that you had not seen this material. This material was not given to you, was not provided to you. So all we can do is put it in terms of hypotheticals. If you had seen material that had bearing on the same facts as were before you in a criminal complaint, and that material showed an auditor saying that the related actions of a municipality were illegal, that would have been relevant to your analysis of the criminal complaint, wouldn't it? It must have been.
I'd like to ask the members of the tribunal if it is necessary that I answer questions that focus on a hypothetical case. I think
Terminado, usted es un testigo de hecho y por lo tanto las preguntas deben de estar restringidas a su actuación y a los hechos.
sorry. I'm going to speak in English and it will be translated for you.
That you are a witness of fact. Your statement has been submitted by respondent as a witness of fact, and the examination is based on your testimony. There may be instances in which a question may be posed to you hypothetically, but with respect exclusively to your witness statement. If that statement if that question, would entail a different set of facts, then that would be beyond the scope of the examination.
Okay, I would say so. I probably won't press this, but I think the point here is virtually all of Mr. Martinez's evidence goes to the scope of investigation and the way in which the prosecutor's office conducted itself. In that context, and I appreciate that's a very wide framing of the context, it is relevant to understand how he would have conducted himself, or the office would have conducted itself, had it had this material. So I appreciate that there is no reference to auditors, to Mr. Briceño, and so on in his two statements, but nonetheless, we would say there is some relevance given the overall aegis of the evidence.
Mr. President, if I can just offer only an observation. And we're confirming this at the moment, but I think we haven't shown Mr. Martinez anything to do with Mr. Briceño for precisely the reason that is now being raised. We have not conflated Mr. Martinez's role with that of other institutions, and so I just wanted that to be borne in mind in this regard. I know we are, of course, we're in possession of all of the information in this arbitration.
Right. Yes, the Yeah, the tribunal believes that we should restrict to the facts that were available to Mr. Martinez at the time, and that questions that could be speculative with respect to facts that could have been available back then but were not, should not be addressed, nor should he be required to respond.
Thank you, sir.
Thank you.
Moving on, Mr. Martinez, there's the question of the forged document to which you've already referred. Now, I'd like you to turn to tab 39 in the materials before you, which is still in volume 1. Thank you. Somebody's coming to help.
Gracias.
So you'll see on the first page of the document, there's the date 27 March 2008. You see that?
Correcto.
Correct?
Now, can you just flick on in the copy of that document? You go to the very last page, and then go back one page. So to the second last page. That's it, on the right-hand side there. Just a handwritten note and a stamp. You see that? So you can see every page of this document has the same stamp on it, which one assumes was made at the time of receipt at the relevant office. Can you just read out that handwritten note?
Yes, surely, sir. What it says in handwriting here, it says submitted by Mr. Stephen actually reads more like Setena. Aven Bucelato on 28 March 2008 in the file department. Setena has 4 photos and several photographs. This stamp on the left-hand side with a signature is not from Setena. It is from the Aguirre legal court. It's of the judiciary of that area. They are the ones who are certifying the copy. So it is a judicial stamp. It's not a Setena stamp.
Thank you for that. But you can see that the day after the date of this document, there's a record of Mr. Bucelato putting it on file. You see that?
Yes, the note is dated 28 May, and the other document, and the document itself is 27 May.
So 27 March on the date of the document, 28 March. Yeah?
Sí, sí, correcto. Fue un error.
Yes, correct. I did make a mistake.
Fine. Now, this document overall was terribly important for your analysis, wasn't it? For the work you did, for considering criminal charges and so on.
That's correct. This document was, I analyzed it, and in light of a section of what had been in Mr. Buccelato's complaint to the Office of the Prosecutor, saying that this was a falsified document, and it's based on that complaint, and having seen that it existed in the Setena file, I personally and directly interviewed the individuals whose names appear signing here, which are Mr. Quesada Avendaño and Vargas Brenes. I interviewed them directly. I had Mr. Gabriel Quesada Avendaño and Ronald Vargas Brenes come to my office, and I asked them if the signatures here and if the documents, of which we had a copy here, if the document had been drawn up by them and signed by them. They both denied this fact. They both denied that this was their signature, and they denied that they drew up this document. Subsequently, I interviewed the person who receives the documents at Setena. It's a single person who receives documents for files, and she told me that there was no way to determine who had actually submitted the document to that institution. At the time, this note on the last page was not, we never saw it on file. At the time of the investigation, we never saw this. And it's kind of curious that that page is not numbered. You will see that in the other pages, in the documents on the upper right-hand side, there is a number that begins with 3 zeros, and then it runs from 258, or rather, I should say, from 251 to 258. Setena numbers the pages in the reverse order than what we do at the judiciary. So this handwritten note, what I can note is that it doesn't have that stamped number, and this is something that I noticed at the time.
Correct. But perhaps I can help you with that. Would it surprise you to know that this note was found on the reverse side of the relevant page in the original file? And therefore it does not have one of these stamped numbers to which you refer. Change your view of whether there's anything odd about the fact of that note?
Yes, what I must tell you, sir, is that Setena, in this case, for this document, you can see that both of the sides, recto and dorso, they're both stamped with a number. I am surprised to see that this page does not have a number. It looks strange to me. I'm surprised by it. But actually, when the investigation was conducted, neither I nor the attorneys who defended Mr. Aven at various steps, they never referenced or mentioned the existence of this note, and this Setena was available to the defense and to the accused at all times from when evidence was gathered, and it was available to him at the time of the formal investigation. It's a point in which the person who has been accused or who is being investigated, they are presented with the evidence brought against them. So I'm surprised that it's only now that this note appears. And rather than surprised, let me say, is that at the time of the investigation, neither I personally nor any of the individuals who were working on the file referred to it. In any event, I should also add that the investigation having to do with the use of falsified document and the existence, and something that Setena denounced, my decision was to file it in the case of David Aven.
But you seized the Setena files right at the beginning of the process. We saw that, right? So you seized the original files, correct?
Es correcto. Hace un rato.
That is correct. We saw a resolution ordering that seizure.
Copies were taken and distributed and used in the proceedings of the actual document itself, which is everything other than that page with the handwritten note, the copying wouldn't have been done of the reverse side of the paper, would it? So it's possible that everybody just missed the fact there was a handwritten note recording the receipt onto the file of the document, right? It's possible that that was just missed.
That's a possibility. However, what is a fact is that the copies of the files in the office of the prosecutor, the copies of the main file, and of the evidence gathered by the office of the prosecutor is not generated by them or by that office. Each of the parties come, and the Costa Rican attorneys who are here can say, each of the parties come, they request the documents, and they look over it individually. If they decide to copy it, they decide which pages they want to copy. But this is a decision by the defense or by the accused. Anybody makes their own personal decision as to what copies they want to make of a document that is part of a criminal investigation. We do not give them the copy.
You're the prosecutors, you're the ones who are investigating, you're the ones who are considering whether or not to bring criminal charges against individuals for an offence, in this case of dishonesty, which is therefore a serious matter. When you're looking at something like an allegation of a forged document, you're not just going to have a quick look at it, have a chat with the alleged signatories who say they know nothing about it, and that would be the end. You must have considered subjecting this document to forensic analysis in its original form. You must have done that, mustn't you?
No, it was not done, and for several reasons, sir. The document on the Setena's file is also a copy. It is not an original document. The forensic analysis would have been relevant had the individuals whose signatures are there would have pointed out that indeed this was their signature. Then maybe it would have been necessary to determine that it wasn't authentic. Then we would have had to conduct a forensic study. But at the beginning of the investigation, it was clear for several reasons that the document itself was a forgery. This was confirmed by the people whose names appear, and the office that is mentioned here, Esterillos Oeste, doesn't exist. So all of these elements are things that I looked into.
Enough to satisfy yourself that this was not an authentic document, but in terms of understanding who was responsible for this supposed act of forgery, it doesn't begin to approach a proper analysis, does it? And you can see now, the note that you missed, that the person who put this on the file the day after it is dated is Mr. Buccellati. You can see that, so your inquiries for the forgery you identified have to begin with Mr. Buccellati, don't they? That's the only competent, reasonable way for you to execute your duties, right?
No, that is not correct. In my opinion, Mr. Buccellati had no interest in using a falsified document. This falsified a falsified document, according to Costa Rican legislation, is to obtain a benefit. In this case, the document would only be beneficial to the Las Olas project because what is stated here is in favor of that project. So one could not think that Mr. Buccellati would have submitted this document in order to favor the Las Olas project. Therefore, the investigation, had no reason to focus on this individual. As in fact, when Mr. Buccellati filed the criminal case then he presented this document that then became part of the criminal file. The fact that he submitted it for the criminal file, to think that he was committing a crime and using falsified documents, in my humble opinion, is not correct.
Begin to see the possibility. Frankly, I have no idea whether this is the correct version of events or not, but it's your job to investigate the possibilities. Do you not begin to see the possibility that the person who is recorded on state files as having deposited a document you subsequently discover to be a forgery might have done it in order to line up an attack of precisely this sort later on? Do you not see that as a possibility?
Yes. Possibly that was the intention. I do not dismiss this as a possibility, sir.
Thank you. And just go back to your witness statement. I want to have a quick look at paragraph 21 of your first witness statement. You indicate there that you discussed studies and technical reports that you needed as part of your investigation. And you did various things. You say that you asked CNAC, ACOPAC, the local office of CNAC, to determine whether there was a forest on the project site. You say that you went to the National Wetlands Programme within CNAC Minai to ask them to send the technical criteria on whether there were wetlands on the property. And you asked INTA to take soil samples at the project site. All of that's correct?
Es correcto, sí.
Yes, it's correct.
And you say that the reference to INTA was related to the Soil Use Handling and Conservation Act number 7779. We see that at the end of that paragraph.
Sí, es correcto.
Yes, that's correct.
Perhaps you could turn to tab 22 in volume 1. This is exhibit C116. While you're finding it, I'll just confirm that this is the 18th March 2011 CNAC inspection report. Now this is the report submitted by Jorge Gamboa Elizondo from the National Wetlands Project. I'd like you to go a little way into the document. Go to the 11th page. I think the number that's stamped at the top there is 000039. Might be 38, but I think it's 39. Now you see that there's a conclusion that there was a Palestrine wetland being affected by the construction of a drainage and sewage canal. Now that's not consistent with the report from CNAC of 16th July 2010 to which we referred, the one made by Mr. Bagantes and Mr. Manfredi, the document C72. There's an inconsistency there, you'd accept. I think you've already accepted that there are multiple CNAC reports saying there are no wetlands. There's one that says there's a possibility of a wetland. There's one that refers to apparently there being wetlands. And now we have, and this is what I think you were referring to earlier, something from the National Wetlands Programme saying that there are Palestrine wetlands being affected by the construction of a drainage and sewage canal. Yes?
Sí,
Yes, these reports, seen as I was telling you a moment ago, looked at then just from a simple point of view, they seem in effect to be contradicting one another. But during the criminal investigation, the prosecutor must weigh the evidence to see the likelihood of a crime being committed, and it is then when you decide when you evaluate when was the date or the site when they were issued, the people who issued them, their jurisdiction, and then you make a decision at that point, or at this point we made a decision that made us have to look at environmental principles. And it was then at that point that we considered that there was the probability that a wetland drainage crime had been committed, and the possibility that that wetland did exist in effect and that it was being impacted when this work was being carried out.
You could just go back to the third page of that report. You'll see halfway down the page there's a section Cuarto. Would you agree with me that this paragraph indicates that the municipality has been carrying out piping work in the southern portion of the property? You see that? And see the reference to that work, according to interviews, being intended to dry out alleged wetlands. You see that?
Yes, I do. This paragraph is a transcription of the APOCAP 03/01/2003 letter to which we made reference, and we discussed this matter a moment ago. The people from the wetlands program is referring to the previous letter of APOCAP where they had made this reference.
What did you do to investigate the municipality's work and its impact on the site?
I don't have to explain it once again, but I had already answered this question because regarding this letter, we had already previously spoken with you, the attorney. You had asked about the investigation we had made.
Las preguntas.
Please reply to the question that Mr. Burns has asked. Yes, in effect, because of that indication, we asked the municipality if they had carried out any kind of work within the property. They answered that the work had been carried out outside of the property to channel rainwater going towards a place which, if I remember correctly, is called the Estero Aserradero.
Of the inquiries you commissioned was with Inter. And could you turn to tab 25 in volume 1? This is exhibit C124. 25. Before that, I neglected to ask this question when we were just touching on the municipality. Did your office make a written request to the municipality for copies of its documents?
¿de cuáles documentos?
Of which documents? Which documents do you refer to, sir?
Documents relating to the Las Olas site and the municipality's dealings with the developers over time. Did you make any sort of written request of that sort?
I think that we did make a request to find out if there were construction permits granted by the municipality.
And specifically about the piping work we've seen reference to? Did you make any requests for documents relating to that piping work?
I seem to recall that we did ask that they indicate if, in effect, they had carried out any kind of pipe laying.
The records come into the arbitration, but we can pick that up later perhaps. Turning back to Exhibit C124, the Inter report, you went to them because you knew, didn't you, that in order to establish whether or not there was a wetland, one of the mandatory elements was that there was the requisite quality of soil in areas on the site. That's right?
Correcto.
Correct.
And then you can see on page 8 of that report, Inter reporting its conclusions after it has undertaken its analysis. And you can see paragraph 5 in conclusions that they conclude that they do not see evidence of soil that is typical of wetland areas. You see that?
Correcto, sí.
Correct, I do.
That ought to terminate your entire investigation in relation to wetlands matters, no? That's the end. END.
No,
No, sir. This document was one more document that the prosecutor's office had to analyze as part of the investigation. In the two previous opportunities in which I spoke about weighing the documents, I indicated that the context in which it is issued has to be analyzed, the conclusion that is being issued, and in this case, the Wetlands National Program, when it issues its report, states that there are hydric soils, which are the ones that are normally required according to the regulations and according to my own experience. Those are the ones that usually are defined as part of a wetland. So in this case, the conclusion that INTA is referring to is that they might not be typical of a wetland, but that you have to bear in mind the historical moment when the inspection is done by INTA. And that is at that point, well, I took the gentleman from INTA to that site personally, and at that specific point, the site had been filled substantially. So all of these elements were weighed at the time when the decision was made.
So in effect, what you're saying is you knew better than the experts about soil quality and you could just ignore their report, right?
No, I'm not saying that. What I'm saying is that in the National Wetlands Program report, reference is made to the existence of soils that can classify the site as a wetland.
Right, well, I think you can see the specialists, INTA, the agency dealing with soil classification across the country, have said quite clearly to you, there's no evidence of soil of the right quality existing on site. And you made a call to ignore that finding and pursue Mr. Aven and Mr. Damjanac regardless of the fact that one of the mandatory elements of the offence was the evidence that you had commissioned showed it was not there. That was your judgment, wasn't it?
Yes, as I mentioned before, when weighing the evidence, that is when the public prosecutor's office weighed the evidence, we took into account the indication of the National Wetlands Program, which was completely credible to us at that point. And based on that, we made the decision to present charges because we were sure that that it showed probability. And with that, we were able to continue progressing, and that's when we brought this to trial. This was assessed by independent judges that are not part of the prosecutor's office. Their role is independent within the judiciary branch, and so this weighing analysis was carried out.
Just thinking about the criminal trial itself, you'll recall, because you were there, you were one of the protagonists, that at the end of the trial there was an adjournment, and then the judge had a medical issue with respect to some surgery on his hand, and he was not able to return on the scheduled date. Now, you'll recall that Mr. Aven's counsel, Mr. Moreira, asked you to agree to find another judge to take over the case. You rejected that request, didn't you?
In effect, I rejected that request because within Costa Rican legislation there is a regulation that states that if it is more than 10 business days that the trial adjourns, then the previous material has to be annulled. So within Costa Rican law, we cannot replace a judge who has been present throughout all the cross-examination, who has been able to intervene, to participate, to listen to the parties, or to hear the parties directly, to replace him when all of this has happened, so that only with videos the second judge makes a decision. He can hear what the parties say, but if he has any questions, he cannot ask for clarification. So according to our procedural law, these regulations are clear. They govern the criminal process in the whole process through debate, examination, cross-examination, etc. So the request by Mr. Moreira was simply completely crazy, and I'm sorry to say that.
Rejected the waiving of the 10-day rule. That's a rule that's there to protect defendants from criminal proceedings continuing on ad infinitum. You rejected that request as well, didn't you?
Yes, correct. I rejected the request made by Mr. Moreira also to continue after the 10 days because obviously that rule is one which, in my opinion, is not aimed at only protecting defendants, but also to protect all the parties in the procedure. The rules established within the Costa Rican Criminal Code, from that point of view, the point of view of principles, have not been aimed at protecting only the defendant. All the parties of the procedure have to be able to benefit from that possibility. Now, it was not an arbitrary decision. At that point, I analyzed case law, appeals, courts in my country, case law which stated that even when appeal courts observe that this 10-day rule has been violated, even when there's been agreement by the parties, they order the annulment of the procedure because there's been a violation of the principle of contradiction or the principle of the presence of the judge in the discussions.
That is absolutely fanciful, isn't it? The idea that the state, in a criminal matter, needs to be protected from some sort of prejudice in relation to a continuation is frankly ludicrous. You have nothing to protect yourself from except the difficulties of what would otherwise be a failed trial. You just wanted to use this rule in order to capsize the first trial in which you had failed to prove your case and have another go and keep everything going against Mr. Aven. That's the fair way of understanding your decision to reject the request to waive the 10-day rule. Correct?
No, sir, I cannot agree with your assertion because the prosecutor is not the only procedural party that is there. During the discussions, there are many more parties to the procedure. There is the victim, for instance, and other types of crimes, and even in this type of crime where the victim is represented by the General Attorney's Office. that is the General Attorney's Office of the Republic. And in addition, the trial we had done up to then, at least the way I or our office had seen it, is that we had managed to show the facts that we were attributing to the defendants. In that procedural stage, I, more than anyone, was interested in having this procedure conclude. I had 2 open trials. I was going from one place to the other, so that the criminal procedure that was being carried out in Quepos come to an end. However, the problem is that there was no guarantee that, given this waive that Mr. Moreira had been requesting, if there was a sentence against him, we didn't want him to then say that that 10-day rule had been violated. I opposed this negotiation in order to have a new opportunity, because in any new opportunity that might have arisen during that procedure, we would have had to go with the same evidence that we had already submitted. The public prosecutor's office in my country cannot submit additional evidence once the charge is brought. Once the charge was brought, then the public prosecutor's office cannot show more evidence or cannot accept more evidence for better settlement. So that rule of better settlement is normally reserved for the defense, and the attorneys present here from Costa Rica know that.
Grateful for your confirmation that the state would not in fact have been prejudiced, that it would be confined to the evidence already heard. One last question to you. I think it's one last question. It does depend on your answer, I guess. But one last question to you, Mr. Martinez. If Mr. Aven had been charged with a misdemeanor offence, for which a fine would have been the maximum penalty, you couldn't have sought his extradition by way of an Interpol red notice, could you?
Correct. In order to proceed with this red notice, the crime that is being investigated needs to be punishable by prison.
I have no further questions.
Before determining whether we're going to take a break for lunch at this time, you expect to do some redirect, Mr. Leithley?
Thank you, sir. Yes, I do. I can be finished before 1 o'clock, so in fact, maybe even quicker than that. 5 minutes.
If the court reporters and interpreters are available for these additional 5-10 minutes, and there will be some questions on the part of the tribunal as well, so we would have to take that into account. Are the court reporters and interpreters available?
If you wish so, we can break now, and given we have, of course, in my ignorance, had forgotten, of course, the number of questions that will come from the tribunal, so we're very happy to wait until after the break.
Would we do? You're fine? Okay, so I think if court reporters and interpreters are fine, then the tribunal is fine with that as well. Of course, we have more stamina because we haven't been probably working as hard as they have. So please proceed then.
Thank you, sir. Señor Martinez.
Mr. Martinez, I just want to add a couple of questions as far as that is on behalf of Costa Rica. Regarding Mr. Burns' question on the crime charged in the criminal case, I would like to make reference to the document which is in tab 33, which is there in your bundle. The prosecutor's charge, yes. Can you see this document? Did you find it? You have it there before you? Yes, I do. Could you go to the last page? What is the date of this document? October 21, 2011. Could you go to paragraph 5, to the 5th paragraph, where it says quinto, 5th paragraph, I think it's on page 4. Yes. And could you please read that paragraph 5. Let us begin at the middle of the paragraph, or rather the first half of the paragraph. Could you read it aloud? The fifth, it says, without specifying a precise date, but since April 2009, the accused David Richard Aven, on the basis of the residential condominium and the owners of the lots that had been on the property 6142646, indicated that the gradual filling of the wetland that is in the west of the project. Since these actions increased in between November 2010 and February 2011.
So whilst you've been reading, I've been corrected by my colleague that this is also translated behind tab 34 of your folder into English. And the purpose of my question was to read it onto the record. But entonces no hace falta
So you don't have to read it all because the document is already in the record in English, so that you can stop there. But my question is, and could you read paragraph 6 and 7, please? Aloud? No, just for yourself.
Sí, señor.
Yes, sir. Having read these paragraphs, can you say when, in which years, these events that were the basis of the charge happened? From April 2009, or rather, only from the basis of this last paragraph? No, sorry. Paragraphs 5, 6, and 7, the dates there. Well, with regard to paragraph 5, they state here that it began in April 2009, but that this increased, that is, these filling tasks increased between November 2010 and February 2011. And with regard to the facts attributed to Mr. Damjanak, those facts related with the illegal logging of trees, that is between November and December 2010. Other events in October 2011 and a specific one on September 9, 2011. Thank you very much. Mr. Martinez, in the Costa Rican criminal procedure, the prosecutor's opinion links the judge? No. What the prosecutor's office, what it does is pose a legal hypothesis. Then the judge can qualify that if the events that have been charged are under another standard. So the legal qualification done by the prosecutor's office is one that is done, if I may, it's of a temporary nature. And then it's the judge who makes a decision regarding the legal issues. We have something that says that what are charged are facts and not legal qualifications. Thank you. Mr. Martinez, do you know, and don't worry if you don't remember, if Mr. Aven was represented by an attorney at that point during the criminal process? He was represented by attorneys from the moment in which we began the inquiry. That is, throughout the whole criminal procedure, he has been represented by an attorney at law. I only have one more question. Could you go to tab 25? Yes, sir. That is the letter by INTA. I'm sorry, I don't have the reference for the record, but
Again, please.
C12.
Thank you. ¿Se acuerda de este documento?
Do you remember this document from Mr. Burns' questions? Yes, I do. And if I take you to paragraph 5, quinto, in the page, on page that has the number 8. Yes. And we were asking questions, or you were being asked questions about INTA's conclusions, and you've made reference to another evidence or another soil test that you took into account. Could you expand on what you were talking about? Yes. The reference to the type of soil is in the report prepared by the National Wetlands Program, where they state that they're hydric or water type soils.
Okay. Pedro, ¿alguna? Okay.
Pedro? Mr. Martinez, and I understood, but please confirm this for me. If with regard to the investigation that you led up, conceptually speaking, did you consider that the conception of wetlands does not necessarily correspond to a WPA? Do you understand that or as I should understand, there can be wetlands that are not within a wildlife protected area? That is correct. There's another thing. It's really a comment, not a question, and I wonder if it's in the record. The note from 25 March 2008, sent by fax from architect Madrigal to Gerardo Chavarria, which then indicated that the project was not within a WPA. And this is for the parties. The sentence, the property is not within any wildlife protected area, is in a response. Well, that at least Mr. Chavarria asked the architect Madrigal, but the note sent by architect Madrigal to Mr. Chavarria, well, that could help us see within what context wildlife protected area was used. I'd like to know if that's in the record.
We think the answer is no, but we can double check that. We think that is not in the record.
Confirm it, so if I may.
Just for the record, the document to which arbitrator Niken is referring to is the C48, which is in tab number 6 of this cross-examination bundle. Any further questions, Mr. Niken? No? Mr. Baker?
Thank you, Chairman. Mr. Martinez, how long have you been a prosecutor?
Yo ejerzo
I began as a prosecutor in February 2008. Well, 8 years, practically 9. Just in a few months, it'll be 9.
Before you became a prosecutor?
Sí, muy bien.
Very well. I'm an attorney since August 2001. I've been a lawyer for 15 years. Initially, I worked some 2 years in a firm, litigating. Thereafter, I began to work in the Ministry of Finance in 2003 as a public servant. I was there for almost a year. Then I worked in another ministry, which was the Ministry of Justice, in the Office of Social Adaptation, which is an agency devoted to supervising those people who have been convicted. And since 2005, until I went to work for the prosecutor's office, I worked at the Attorney General's office. Just to clarify, there are 2 agencies. One is the Office of the Public Prosecutors, which is under the judicial branch, and then the Attorney General's office, which is like the Attorney of the State. From 2005 and 2008, I worked in the criminal section. Well, with regard to environmental claims, I was an assistant to the coordinator of the criminal department of the state, the Attorney General's office.
Answer correctly. Prior to 2005, you had not been involved in the environmental legal practice. Is that correct?
Es correcto.
That is correct.
To work for the Attorney General in the criminal division began to deal with environmental matters. What is the difference, briefly, between what the Attorney General's office does and the Public Prosecutor's office?
Sí.
Yes. Well, let me begin with the prosecutor's office. The prosecutor's office carries out criminal investigations in a direct fashion. When there is a complaint, then the prosecutor's officers takes all steps to investigate whether a crime has been committed, who committed it, when, where, and finally it makes a decision whether it will file an accusation or to shelve the file or to dismiss it. And then it will go forward throughout the proceedings, all phases, the arguments phase, and then thereafter appeals or criminal sentencing. And the Attorney General's office, with regard to environmental matters, has the representation of the victim. And so that is the victim as such. And as the victim in criminal matters, well, they must file the criminal complaint, which is a subsidiary accusation or parallel to the one presented by the prosecutor's office. And also, it is incumbent on them to also file the civil action for reparations, which could be linked to any criminal conviction. So the civil and the penal action that goes forward, once the prosecutor's office has finished and has an accusation, then thereafter the Attorney General's office may intervene as a party, and so they will also accompany the prosecutor's office throughout all the phases that I have just laid out for you.
One of the key differences that I understand from your answer between the two is that in the public prosecutor's office, the attorney or the public prosecutor, acts as his own investigating agent, which he does not in the Attorney General's office. Is that correct?
La Procuraduría tiene
The Attorney General's office can carry out investigations, but it's not normal for it to conduct investigations. The Public Prosecutor's Office does, using technical agencies, and in order to figure out who's responsible for the crime, an institution that is called the Bureau of Judicial Investigation. They have experts, investigators from different disciplines.
Before becoming a public prosecutor, while you were still at the Attorney General's office, did you conduct any such investigations yourself?
No. When I was at the Attorney General's office, I did not conduct any kind of investigation. What we did is, to some extent, we verified that the steps taken by the prosecutor's office were correct. When we wanted to file civil action or a criminal complaint, to make sure that the procedures followed would allow for success. So we would review the prosecutor's office steps without any control over them, just to be certain that what the Attorney General's office was accusing in, for example, this civil action would be successful in the criminal proceedings.
To me. So in other words, if I have it correct, the Attorney General's office, you would review the public prosecutor's completed investigation and the criminal complaint, but you would not participate in the investigation on the front end or the public prosecutor's decision on what charges to bring. Do I have that right?
Eso es correcto. Sí.
That is correct.
Became a member of the public prosecutor's office, and before I go there, actually, how does that happen? Do you apply? Are you appointed by the judicial branch? Is it appointed by the political branch? How does one become a public prosecutor in Costa Rica?
Sí, muy bien, el ministerio.
Very well. The prosecutor's office is under the judicial branch. It is under the judicial branch. To be a prosecutor at that time and to date, there are exams, very rigorous exams given by the prosecutor's office, where you must show your knowledge of criminal law, special laws, and also criminal procedure. Thereafter, if you pass the exam stage, then you can have access to a post. Then you must go through some training, which lasts about a year. Well, I think at that time it was about 6 months. I think it's now a year. During that period, you receive training from prosecutors who have a great deal of knowledge, and you receive training from these people in procedural matters, investigative matters, criminalistics, forensic matters, criminal matters. And so once you receive this training, you are then eligible to be given a post throughout the nation. And that appointment depends on the grades that you got on your exams and the grades that you got during the training. During, well, the 6 months, there are different exams that are given. And so this depends on the grades. When someone is appointed, well, you go from the person who gets the best grade, and then you go down, and then when there are no posts left, well, that's it.
Is one entitled then, as a civil servant in the public prosecutor's office, to have that position for the rest of your career unless you decide to change? In other words, is the term of appointment, once you are given one, forever, like it is for judges in many countries? Or do you have to be reappointed at a consecutive basis?
No, en mi país
No, in my country, there are two concepts. One, you could be there with tenure or without tenure. So I went in 2008 without tenure, and then I got a tenured post in December 2013. And non-tenured and tenured positions have nothing to do with being a lifelong judge or prosecutor. We must always be subject to a disciplinary regime that governs any public servant in the country. If you commit any kind of action which might cause you to be dismissed, you could be dismissed if you're a judge or prosecutor if it's proven that you have committed wrongdoing.
Turn to when this case began. How many investigations into environmental crimes had you done before you began to investigate Mr. Aven?
Very well. I can't give you an exact number of how many investigations I had conducted, but what I must tell you, and to give you some context, in the places where I have been carrying out environmental crimes investigations, in 2009 and 2010, I was conducting environmental investigations in a province which is called Guanacaste in Costa Rica. The environmental prosecutor's office has an office there where all kinds of environmental crimes are investigated. The current practice is, in that office, they get about 200 files a year. So I would have less than that, but between 2009 and 2010, I may have handled, being modest, 300 cases. And then as of 2011, where I went into the environmental prosecutor's office, it's a special prosecutor's office that has its headquarters in San Jose, and it only looks at cases from different jurisdictions throughout the country, but more complex cases. In the provincial offices in Guanacaste, there are complex matters or cases, but there are less complicated cases and not necessarily dealing with the very specialized laws that are about the environment in Costa Rica.
With the number of investigations, and I would include both the period where you were at the provincial office as well as when you moved to San Jose, what percentage of those cases actually led to the filing of any form of criminal charge? Approximately.
It's very difficult to give you an exact number. At that time, if you counted them, well, it's not data that I would think was relevant for answering a question 8 years later. Well, my experience indicates to me throughout this time that more or less 50% of these environmental proceedings end up with a formal accusation. Even the ones in my office, I could say that practically half of them end up with a formal accusation. The other 50% probably will end up with a request for dismissal, or which is the way usually to shelve cases in my country. We also have something called sobreseimiento, which is also like dismissal.
50% that lead to the filing of some complaint, what percentages of those are felony cases and what percentage are misdemeanor cases, in your experience?
En Costa Rica,
In Costa Rica, we don't have this kind of classification between felonies and misdemeanors. Well, maybe we call them infractions. All crimes that we deal with either have penalties of prison or penalties of fines, but they're all crimes. But my investigations.
That very helpful suggestion, because I want to put it in the right context. How many of those 50% of those cases that led to a charge were cases resolvable by fines? And how many were resolvable with the possibility of a prison term?
I don't have data to give you a percentage, sir. What I can tell you, the kinds of crimes that lead to a fine in our laws, well, there are 110 environmental crimes. Of those 110, 90 of those are penalized with prison and the rest with fines. Most crimes that can be sanctioned with fines have to do with the fishing law, and the others have to do with forest law. No, excuse me, not in the forest law. I'm just talking about, for fines, it's just fishing and a few others, but most of them actually have sanctions, which are prison.
Get at the information this way. In your personal experience as a member of the public prosecutor's offices, how many cases did you bring where the punishment was for a prison sentence and the matters involved allegations of wetlands, other than the Aven case?
sí,
Well, when I was in the province, I remember a case that had to do with a place called Losada in the province of Guanacaste, where there was the accusation of filling a wetland where there was a gas station. I remember that in Nosara, there was another one because a house was built within a wetland. In 2010, at the beginning of 2011, I personally accused the owner of a business called Pedregales in Costa Rica. We had a one-year trial. This person was convicted for 7 environmental crimes, actually. I'm still working on a case known, well, for constructing a highway. It's on the border between Costa Rica and Nicaragua. We call it the Trocha Costa Rica. Well, the attorneys from my country have certainly heard of this, and it has to do with the issue of wetlands. And just trying to remember, well, 4 or 5 cases that I can tell you off the top of my head. But perhaps it's probably more, because these are crimes that are quite frequent in my country.
With your personal experience in these types of matters which have the possibility of penal sentence, you told me about one conviction which involved 7 environmental crimes. You mentioned 2, perhaps 3 other cases plus an ongoing one. Of the other ones that you could remember and mention, were they resolved by judgment or by settlement between the parties, or a plea bargain, as we would say here?
Miren, los,
Well, in environmental crimes, a large percentage, a very high percentage of the criminal proceedings have to do with environmental matters, are resolved with alternative measures. I don't have exact data, but my experience indicates to me that very few proceedings get to trial, because usually the parties negotiate. Usually they negotiate. In Costa Rica, there are 3 kinds of figures that allow for negotiation with regard to these kinds of crimes: conciliation, the suspension, and the other reparation, or full reparation of damages. 90 to 95% of the criminal proceedings in which I have presented accusations, the parties, the defendant and his or her attorney, and the victim, in other words, the Attorney General's office, we reach an agreement in this document that the claimant presented. There are some specific provisions which oblige us to weigh 3 aspects with regard to those negotiations, and we use them when we reach an agreement. We consult with this when we are undertaking negotiations, and we seek that the negotiations are in keeping with these guidelines or our policy on that.
Subjects for a minute, Mr. Martinez. Do you have a piece of paper and a pen or something to write with in front of you? It may help you for what we're about to do. I want to try a little exercise, if I could, with the chairman's indulgence, to see if you can help me make sense of what is a very complicated fact pattern. So what I hope to come out of with, just to tell you where I'm going, is essentially a chart which will have 3 columns in it. And in the first column, I'd like you to list for me the expert agencies or investigative bodies or municipal bodies that you, as an experienced environmental prosecutor, believe should be consulted in a case where there is an allegation involving destruction of wetlands. A top to bottom list, if you will, in the first column of the chart, of all of the expert agencies or expertise that you could call upon in your role as a prosecutor to help you make a determination as to whether or not a violation of environmental wetlands statutes has taken place. Does that make sense for column 1?
Correcto.
Okay?
Correct.
Just give me your list. New matter has come to you in the file, and it involves an allegation of wetlands. Who are you going to pick up the phone and call? Which agencies? Yeah, I've got another 20, 30 minutes. Okay. That's fine.
Just for reference of court reporters and interpreters, once Mr. Baker addresses the composition of this chart, we're going to take a break because his examination may take approximately 20 to 30 minutes more.
And Chairman, I'm perfectly happy because the most of the substantial work that I've asked the witness to do is going to be in column 1. So as a practical matter, since he's going to be sequestered anyway, we can give him homework over lunch. And he can continue to work while he's eating his luscious sandwich that I'm sure will be provided for him. And then we could return to a finished chart on column 1. Sorry about that, Mr. Martinez. You want to do that? Yeah, so as long as you're clear, because if you can get, for me, and this will give you a chance to think about it too, the most complete list of the technical expertise that you would have available to you to consult with about a case involving wetlands. And we'll start from there when we come back after lunch.
Just to make sure, Mr. Martinez, sí entendió correctamente.
Did you understand correctly what Mr. Baker has asked of you? Yes, I understand. It's quite clear. He wants a list of all the specialized entities that you would consult if it were a wetlands-related case. Yes, I understood. What we're going to do now is have a lunch break. During this time, in any event, you're sequestered, so you cannot consult or talk with any of the members of the team on the side of Costa Rica. So we'll have our lunch break, and when we come back, we will continue with Mr. Baker's witness statements.
Claro. Y mientras
And obviously, meanwhile, you will be given something to eat. Well, thank you.
To avoid any difficulty.
Please.
This reflects the creative but slightly unusual request made from the tribunal for Mr. Martinez. There's no difficulty outside. I just don't want for us all to get into any difficulties with regard to sequestration. I assume that Mr. Martinez should understand that he's not going to be looking things up on a phone either. It's not that I understand where Mr. Baker's inquiry goes, but I wouldn't want there to be any difficulty. So I don't want the witness to misunderstand and to think that he's also meant to research the thing over the break. It's not because I want him to be right or wrong in the answer. It's just that it could create some difficulty with other matters that Mr. Baker may go to in his subsequent questions or anyone. So I think just the terms of the sequestration just need to be clear for the purposes of this exercise.
Just to be perfectly clear, but he would not be restricted to consulting the cross bundle that you have presented in front of him.
Yeah, absolutely fine.
Okay. Simplemente para efecto, do you have any objection to that, Mr. Leithley?
No, sir.
Okay. Nada más para efecto.
Then simply for purposes of clarity, what has just been requested by the claimant's counsel is that in this period you may consult the documents, your statements and all the documents that are on file, the documents you've received in the 3 binders. However, you may not use your phone, nor may you consult the internet or any similar type of thing. Yes, that is understood, sir, and I promise to not do what I'm not supposed to.
It's 25 minutes to 2 o'clock, and we return at, shall we say, 20 minutes to 3?
Could we, I'm just mindful of the marching of time. I mean, would it be possible to make it 2:15 or 2:30? Just worried about losing time. If you think it's better to...
I can eat a fast sandwich. I'm concerned also with the rest of the reporters, which is not only lunch, it's also a true break. Thank you.